Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to briefly discuss President Trump's executive order number 14230, issued against a law firm named Perkins Coie, which was struck down as null and void because it violates the U.S. Constitution by Judge Beryl Howell of the U.S. District Court for the District of Columbia. Perkins Coie is a large international law firm founded in 1912 that represents a variety of clients in matters both related to and not related to the U.S. government. A former lawyer of the firm, Mark Elias of Democracy Docket, previously represented the Hillary Clinton campaign in the 2016 presidential election. On March 6, 2025, President Trump issued the now null and void Executive Order number 14230, titled Addressing Risks of Perkins Coie LLP. The first sentence of Section 1 of the order, which mirrors the language of President Trump, begins with airing President Trump's grievances against the firm in relation to the firm's work for the Hillary Clinton campaign in the 2016 presidential election. Quote, "The dishonest and dangerous activity of the law firm has affected this country for decades. Notably, in 2016, while representing failed presidential candidate Hillary Clinton, Perkins Coie hired Fusion GPS, which then manufactured a false dossier designed to steal an election." The order further states that, quote, "Perkins Coie racially discriminates against its own attorneys and staff and against applicants." Section 2 of the order states that the Attorney General, the Director of National Intelligence, and other relevant heads of executive departments and agencies shall immediately take steps to suspend any active security clearances held by individuals at Perkins Coie pending a review of whether such clearances are consistent with the national interest. Section 2 further requires the Office of Management and Budget to identify government property, materials, and facilities access that the firm has and to revoke such access. Section 3 requires federal contractors to disclose any business they do with Perkins Coie. Section 3 further requires government agencies to identify and review all contracts that may exist with the firm and to take steps to terminate such contracts. Section 5 requires the heads of government agencies to provide guidance to limiting official access from federal government buildings to employees of Perkins Coie. Section 5 further requires the officials to issue guidance limiting government employees acting in their official capacity from engaging with Perkins Coie employees and to take steps to prevent the hiring of employees of Perkins Coie. The law firm sued to enjoin enforcement of the executive order, arguing that the order, 1, violates the First Amendment rights of the firm and its clients due to unlawful retaliation, viewpoint discrimination, and compelled disclosures. 2, it violates the firm's right to due process under the Fifth Amendment. 3, it violates the firm's client's right to counsel under the Fifth and Sixth Amendments. And 4, it unconstitutionally denies equal protection of law to the law firm by singling the firm out for unfair treatment. Judge Howell began her 102-page ruling by stating that no American president has ever before issued executive orders like the one at issue targeting a prominent law firm for adverse actions. Judge Howell states that eliminating lawyers as the guardians of the rule of law removes a major impediment to the path to more power. She cites former Supreme Court Justice Stevens as stating, "Disposing of lawyers is a step in the direction of a totalitarian form of government." Judge Howell references the Sixth Amendment to the U.S. Constitution, which provides the right in all criminal prosecutions to have the assistance of counsel for defense, and the Fifth Amendment of the U.S. Constitution, which provides the right to the aid of counsel when desired and provided by the party asserting the right. Justice Howell cited the U.S. Supreme Court in Legal Services Corporation versus Velasquez, stating, "An informed independent judiciary presumes an informed independent bar." Judge Howell cited the U.S. Supreme Court in Cohen versus Hurley in stating, absent their crucial independence, lawyers would become nothing more than parrots of the views of whatever group wields governmental power at the moment. Judge Howell said that the order stigmatizes and penalizes the firm due to the firm's representation both in the past and currently of clients pursuing claims and taking positions that President Trump disagrees with, as well as the firm's own free speech. Judge Howe quoted the U.S. Supreme Court in NRA versus Wulo, stating, "Simply put, government officials cannot use the power of the state to punish or suppress disfavored expression." The judge in her order states, Perkins Coie's representation of President Trump's political opponent in the 2016 presidential campaign and representation of other clients in connection with election litigation has drawn President Trump's attention and ear, as reflected in his public statements and his filing of a lawsuit against the firm. The lawsuit was dismissed with prejudice less than 6 months later, with the court finding that the lawsuit had no merit. As a result, President Trump and one of his attorneys were sanctioned over $900,000 for, among other things, bringing a frivolous case in order to dishonestly advance a political narrative. In closing, Judge Howe stated, "The U.S. Constitution affords critical protections against executive action like that ordered in Executive Order 14230. Government officials, including the President, may not subject individuals to retaliatory actions after the fact for having engaged in protected speech. They may neither use the power of the state to punish or suppress disfavored expression, nor engage in the use of purely personal and arbitrary power. In this case, these and other foundational protections were violated by Executive Order 14230. On that basis, this court has found that Executive Order 14230 violates the Constitution and is thus null and void." Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.